We have a preliminary matter before we get to that, Your Honor.
Okay.
So let's do that first.
Sure.
Your Honor, we were prepared to complete Mr. Jones's testimony today. We were planning on it. We expected that would take a decent part of the day. We were informed this morning that Mr. Jones is electing not to retake the stand, but to return to Texas. As we were scrambling to figure out what evidence we could present in his absence, which, as you can imagine, given the nature of our client's testimony, is very difficult to do, Mr. Jones was giving a press conference outside the courthouse where he continued his efforts to undermine this trial, attack the court in ad hominem fashion, and make personal attacks against counsel here and our families. He also spoke at length about issues this court has ruled are inadmissible and not for the jury's consideration, including raising his bankruptcy, a host of political issues, and in addition,
there's no gag order here.
there isn't,
And
but
the jury has been instructed ad nauseum about avoiding media coverage.
I understand, Your Honor. He also, though, called on the jury to do research themselves into issues relating to this case. So as we were, and the reason I'm raising this, Your Honor, is because as we were considering our evidentiary presentation, this came to our attention, and we started to consider what relief might be appropriate for us to seek. In light of all this, and in light of our the unfairness, we think, at this point, of forcing us to present evidence and highly important testimony and charged testimony in a way that we weren't planning, we're going to ask for an adjournment today and a return next week.
Can I just a couple of things. Is the adjournment over objection or by agreement?
I agree with you.
And then may I ask, the press conference was in the front of the courthouse?
Correct.
Was it when the jury had already reported in so that there was no issue about the jury overhearing a press conference?
It was immediately after we took our most recent recess.
All right. Ron, Mr. Farr, do you know if the jurors stayed in the building or not?
4 jurors went out.
Okay. All right. So, Attorney Pattis, let me ask you first. Do you have any independent knowledge? Do you disagree, or do you have no knowledge about the press conference? Because my concern, obviously, is that your jurors are, going in and out of the courthouse. I mean, I suppose I could canvass them on it, but do you have any concerns, or do you disagree with the press conference and the calling on the jury to do research? I just need to know what to do here.
Let me tell you what I know. I know that Mr. Jones is going to address the press. I observed from the 3rd floor of this building a gaggle of people. Couldn't see who was there. I asked somebody, is Jones speaking? He is. I overheard audio recording of it from one or more reporters who were listening to it from within the building, but paid no particular attention to it. It's my understanding of the law of the case that I and counsel have independent rules, and even in the absence, independent obligations, even in the absence of a gag order, not to make prejudicial, extrajudicial commentary, and I think all of us have taken pains to do so. I'm unaware of any gag order as to Mr. Jones.
There is none. That's my whole point. There's no gag order, but my concern is just that, the jurors go in and out of the building, and
if in fact, I don't know, I think that we have a presumption that a properly instructed jury follows the law. The court tells them every day to report. The court confirms each day when they arrive that they have not sent a note, thus alerting them to the possibility that they can. They were alerted that there'd be press. They can see for themselves that there is press. I don't think there's any indication that they have seen something. I think given what, I credit what Attorney Mattei says. If he's listened to it, he's heard it. And I apologize personally. I feel mortified that families were involved. I just have no independent knowledge of that. I mean, I'm moved by it, but I think with respect to the interest I'm defending in this courtroom, I think there's no showing to disturb the jury at this point. I think a properly instructed jury is presumed to follow the law, and there is no gag order. And absent some indication of the jury of the need for a canvas, I think this would just be drawing attention to an issue that may be a non-issue.
Well, I think I will address with them, reiterate this morning, just confirm that they are to continue to obey the orders, not to do any independent research. And I think it might not be a bad idea, since some of them did leave during this time, to at least give them an opportunity to, I don't know, let Mr. Farrow know if they did overhear anything.
You know, I mean,
On that note, I will say the jurors who left were escorted by me to the fourth floor garage and all took their cars out State Street, which forces them to go north. I don't know where they went after that.
So you think that they did not go near the front?
They didn't walk near the front.
All right, well, that's reassuring. Okay.
As to the, as to the adjournment, I'd love the day off.
I couldn't hear you say
I
that.
said I'd love the day off. But I think we have an agreement that Mr. Jones will be available and can potentially be taken out of turn